Good morning, everybody. This is the Community Eviction Prevention Training. Thank you for being here today. Nevada, as you may have heard, like the rest of the country, is facing a potential flood of evictions. All of the eviction protections that have been in place throughout the throughout the pandemic are expiring the end of June. So there have been federal protections, there have been state level protections. At the end of June, everything is gone. So across the country, it is estimated that some 5.7 million American households are behind on rent, which is actually down from the 20 million it was in December. But that amount of rent is, sorry, can everybody mute themselves, please? That equates to $20 billion in rental debt that Americans are carrying right now. In Nevada, the estimates range between 142 to 218,000 households are potentially facing eviction. That's a lot of people, somewhere between 327,000 to 501,000 people potentially facing eviction. Now, the real sad part of that is that 75% of those people will be evicted simply because they fail to take action. When they receive an eviction notice from their landlord, they don't file an answer with the court. That's how a tenant protects themselves. So that's what we're going to talk about today. That is the real focus of this program today, to show you how you can assist filing that answer to protect themselves in an eviction. All right, so this is what we'll cover. First, we'll cover an overview of evictions in Nevada, the summary eviction process, how it works, the types of eviction notices. This is not going to be extremely in-depth. It's really going to be just enough to orient you about where you might fit into this procedure. Then we're going to cover the Guide and File program. That's the online program that was developed to allow tenants to go online. They answer a series of questions, kind of like a TurboTax interview, and it prepares their answer and files it for them. That portion is going to be by video, a video that was previously recorded. I'm also going to touch on a new Guide and File program that was just released that is going to be really beneficial to tenants to help them file motions in their eviction case as well. All right, so let's get started talking about the summary eviction process. So the summary eviction process, as the name implies, is summary. It's intended to be fast, to be easy. Most landlords, most tenants can do it themselves and appear in court, file the documents, appear in court themselves. Summary eviction is just about possession of the property. So it's not like the judge is going to decide whether the tenant gets a money judgment awarded against them or the landlord gets a judgment for the rent. It's all about who gets the property. So every summary eviction starts the same way. It starts by the landlord serving the tenant with an eviction notice. That eviction notice will tell the tenant what the landlord thinks the tenant is doing wrong. You're not paying rent, or you're violating your lease, or you're causing some nuisance on the property. To avoid an eviction by default, in other words, if the tenant does nothing in response to that eviction notice, after the notice period runs, the landlord can file a complaint and get the eviction. The court will grant it because from the court's perspective, the tenant hasn't objected to it. So to avoid that eviction, during the notice period, and we'll talk about all of this in more detail, during the notice period, the tenant can go down to the court and can file an answer with the court. So it's a little bit different than most court cases because the tenant, who's really the defendant in the case, is filing first. Sorry, can everybody mute themselves, please? I'm sure there's a way for me to mute everybody, but I don't know how to do that. So the tenant receives an eviction notice, then they have to rush down to the court and they need to file an answer with the court. After the notice period ends, so let's say it's a 7-day notice for non-payment of rent. During that 7 days, the tenant can file an answer. After that 7 days run, then the landlord can go down to the court and file a complaint asking the court to grant an eviction. If the tenant hasn't filed an answer, the eviction is granted by default. If the tenant has filed an answer, then a hearing is required to be set. Doesn't matter what the tenant says in the answer, the very filing of the answer guarantees the tenant a hearing in front of the judge. So that is basically the summary eviction process. We're going to go over it in a little bit more detail. Just as a review, I broke it down into 5 basic steps. So step 1, in every eviction, the tenant will receive an eviction notice. The purpose of the eviction notice is for the landlord to tell the tenant what the tenant is doing wrong. Now, within that notice period, so every notice is there, it could be a 5-day, it could be a 7-day, but within that notice period, the tenant has the opportunity to either comply with the notice or leave. So let's say it's a 7-day notice for non-payment of rent. During that 7 days, the tenant can pay the money that the landlord is seeking and stay in the property. Or during that 7 days, the tenant can vacate. Now, there are 1-part notices and 2-part notices. And we'll discuss that in a little bit more detail, but I just want to point it out to you so you can keep it in mind. Okay, so that's step 1. Step 1 is the notice. Step 2 is the answer. During the notice period, the tenant can go down to the court and can file an answer with the court. The tenant's answer must be filed by the close of business on the last day of the notice. So it's when the court closes on the last day of the notice, the tenant's done. The tenant will file in the court where the property is located. So in Clark County, the 3 main justice courts are Las Vegas, North Las Vegas, and Henderson. So the tenant will file the answer in the court where the property is located. The answer potentially, depending on the defenses the tenant raises under a new law that is likely to get passed, and we'll talk about this later too, the filing of the answer might stay the entire case. But at the very least, what it does, it guarantees that no default eviction can be issued, and it guarantees the tenant a hearing in front of the judge. So this is where you come in. So in helping the tenant to file an answer, this is the step where you will get involved to help the tenant protect themselves so they do not get evicted by default. All right, so step 3. After the notice period runs, the landlord can go down to the court and file a complaint and ask the court for an eviction. Now, 2 things are going to happen. If the tenant has filed a complaint to protect them, an answer to protect themselves, the court is going to set a hearing. If the tenant has not filed an answer, the eviction is granted by default automatically, and the landlord will get that eviction. So step 4, if the tenant has filed an answer, the court is going to set a hearing. Again, it doesn't matter what the tenant says in that answer. By statute, the filing of the answer guarantees the tenant a hearing in front of the judge. The judge will hear both sides and will make an eviction. All the judge is going to decide is either the eviction is granted or the eviction is denied. The judge doesn't have a lot of power to help the parties negotiate or to make some kind of ruling beyond who gets the property. So that's what's going to happen at the hearing. Finally, step 5, I'm sorry. If an eviction order is granted, there are a couple of things a tenant can do. There's something called a motion to stay that the tenant can file, asking for some additional time on the property. There's a motion to set aside that the tenant can file, asking that the whole eviction be canceled for some legal reason, or the tenant can appeal the eviction if the tenant thinks that the judge who granted the eviction simply got it wrong. So those are kind of the three options that a tenant has once the eviction order is issued, but there are no guarantees that any of those will keep the tenant on the property. Once the tenant is locked out by the constable, so if an eviction is granted, the court issues the eviction order, it goes to the constable will go and post it on the tenant's door, will come back within 48 hours or no less than 48 hours and will lock out the tenant. Once the tenant is locked out of that property, they're done. There's nothing to do to get them back in. So that's how the summary eviction process works. It's fairly easy. Notice, answer, complaint, hearing, and then potentially post-eviction motions or post-eviction order motions. So these are the different types of summary eviction. So as I mentioned earlier, there are one-part notices and there are two-part notices. The one-part notices, the big one you'll see is non-payment of rent. That's a 7-day notice. Potentially a tenant could get a 30-day non-payment of rent notice, which is a requirement under the CARES Act for certain properties, but you probably won't see many of those. Most of what you'll see is a 7-day notice for non-payment of rent. The other one-part notice is a 5-day unlawful detainer notice at the end of a lease term. So let's say tenant has a lease expires, landlord serves a notice and says, I'm not renewing your lease and I want you out. The one-part notices, so those two notices, during that notice period, the tenant can file an answer. Now there are also two-part notices. So the first part of these notices tells the tenant what they need to do to save the tenancy. The second part of the notice says, you didn't do what the first part of the notice said, so now I want you off the property. So that could be a lease violation notice. It could be a nuisance notice. There's something called a no cause notice in Nevada that basically is the landlord saying, you didn't necessarily do anything wrong, I just want you off the property. So, and there's something called the tenancy at will, which is pretty rare. So those are the two-part notices. So let's say, for example, a lease violation notice. The first part of that notice will say, this is the provision of your lease that I think you violated, tenant, and this is what you could potentially do to fix that violation. So that is a lease violation is a 5-day notice. So during that 5 days, the tenant can fix whatever the problem is. After the 5 days run, if the tenant hasn't either fixed it or left, then the landlord is going to serve them the second part of the notice, which is a 5-day unlawful detainer notice. During that 5-day period, that's when the tenant can go down to the court and file an answer to protect themselves. So the two-part notices, the tenant can't file during that first period. They have to wait until they get that second notice, and then they can go down to the court and file. Now, the good thing about all this is you don't have to remember all this, because the notice itself will tell you whether or not the tenant can file in response to it. So this is what a notice might look like. This is the notice that will come if the landlord is using the forms at the created by the Self-Help Center. This is what that looks like. They may look different than this. The constable prepares their own notices. Some landlords prepare their own notices. There are certain things that the notice must contain, but broadly speaking, this is what it will look like. Now, here, so this is a lease violation notice. So here in these two top blocks, this will be the tenant's information. This will be the landlord's information. This notice, because it's a lease violation notice, the landlord is required to say, this is the provision of your lease that I think you're violating, and this is what I think you did wrong. Now, importantly, there's a lot of text in these notices, and it's a little legalese. It's a little, it's not super understandable. So, but if you read this notice, you will see that it doesn't say anything about the tenant filing an answer with the court. Instead, what it says is, if you don't cure this problem, you could receive an unlawful detainer notice. So again, during this first part of the notice, the tenant cannot go down to the court to file an answer. If the tenant tries to file an answer, the court's going to reject it and say you have to wait till the second part of your notice. Okay, so this is what the second part of the notice looks like. This is a 5-day notice of unlawful detainer. So one of the big things to look at on the second part of these notices, these unlawful detainer, or sometimes they're called UD notices, is the date of service. That date of service is the date from which you start counting those 5 days. And we'll talk about how you count those 5 days. But it's important that the tenant file within that time period. So in other words, during the 5-day period. Now, if the tenant had received a 7-day notice for non-payment of rent, the tenant would have to file within those 7 days. After the time period runs, the court will probably not let the tenant file. The other important thing about this notice is, remember I said that the tenant has to file in the justice court where the property is located. So that could be Las Vegas, that could be, which is at the Regional Justice Center downtown. It could be Henderson, which I think is out on Water Street, or it could be North Las Vegas, which is in North Las Vegas. So each one of those cities, towns, has its own justice court. So this, the notice will say what the tenant's address is. It's important to verify with the tenant that the address is correct, because the tenant needs to be sure to file in the correct court. If they file in the wrong court, it's possible that their answer is not going to have the effect of protecting them. All right, so now let's talk about how to count the time for a tenant to answer. So you count the time by using judicial days, basically days that the court is open. So the justice courts are open Monday to Thursday. So that means you don't count Fridays, you don't count weekends because the court's not open, you don't count the day that the notice was actually served on the tenant, and you don't count legal holidays. So just as an example, let's say that the tenant received a 7-day non-payment of rent notice on the 3rd. So you would count, the 3rd would be 1, the 4th would be 2, you would not count Friday, Saturday, or Sunday because the court's not open. Let's say the 8th is a legal holiday, so you would not count the legal holiday. So 3, 4, 5, let's see, 1, 2, 3, 4, 5, 6, 7. So actually the tenant would get until the 16th of the month to answer in this example, because you wouldn't count the Fridays, you wouldn't count the Saturdays, you wouldn't count the Sundays, you wouldn't count the day of service, and you wouldn't count the holidays. So that it can be a little confusing to count the days, but if you just stick to that, days the court is open, then you should be fine. But it's important to count the days correctly, because otherwise the tenant could lose out on their opportunity to answer. All right, so now we're going to move away from the summary eviction process and talk a little bit about the tenant protections that are currently in place. So the CDC moratorium is in place until the end of June. Now, the CDC moratorium is not a true moratorium. It really is a moratorium. When you think of a moratorium, it's like no evictions. No, that's not the way this is working at all. The tenant has to take some action to protect themselves and get the benefit of that CDC order. So to do that, the tenant has to sign a declaration and give it to their landlord, basically swearing to 5 things. They have to swear that they have used their best efforts to obtain rental assistance. They earn less than $99,000 a year. They have been unable to pay their rent due to some substantial loss of income. They've been laid off or had their hours reduced. They are using their best efforts to make partial payments of their rent. And if they were evicted, they would either be rendered homeless or they would be forced into some type of group living situation. So the tenant will sign that declaration. The declaration forms are widely available. If you go to our website, we have the forms on there. The tenant would sign the declaration and give it to their landlord. They would keep a copy for themselves. And should the landlord serve an eviction notice, the tenant would provide that declaration, a copy of that declaration, to the court with the proof of service form, saying, on this day, I served my landlord with this declaration, and hopefully the tenant would get some protection out of that. Now I say hopefully because the CDC protection hasn't quite turned out the way we had hoped it would turn out. The courts have really limited the protection that the CDC provides. And they have really limited it really only to non-payment of rent evictions. So other types of evictions, things like lease violations, things like nuisance violations, no cause evictions, or evictions at the end of term when the tenant's lease expires. Most of those will not be protected. But if the tenant gets a straight 7-day non-payment of rent notice, the CDC might protect them. Now, the unfortunate part of this is as soon as landlords learned this, they stopped giving non-payment notices and started giving all the other types of notices because they knew that the tenant wouldn't have any protection. We've been really lucky because the state moratorium that Governor Sisolak signed has been in effect, and it's been pretty broad and effective, but that's gone. So the only thing we have right now is the CDC moratorium. The other issue with the CDC moratorium is courts are looking at that and saying, well, really all it prevents is the actual lockout of the tenant. In other words, all of the court procedure up to the actual lockout is okay. So the landlord can file an eviction notice, the tenant can file an answer if they choose to do so, the landlord can file a complaint, and the court can actually issue that eviction order. The court is saying that the only thing that the CDC is going to prevent is the actual enforcement of that eviction order. So potentially by June 30th, when the CDC moratorium expires, there will be a lot of eviction orders just waiting to be enforced. The other problem is that there are different versions of a tenant declaration floating around. So under Governor Sisolak's state level moratorium, a tenant didn't have to swear to the same things as under the CDC moratorium. So the declarations are different. Some tenants have given a state level declaration that doesn't include all of the things that the CDC declaration requires. So we're really encouraging all tenants to review the declaration that they gave their landlord. And if they have any question about whether that's a CDC qualified declaration, just give your landlord a new declaration. Just sign a new declaration and give it to your landlord. Again, the declaration forms are available on our website, lacsn.org. We have a COVID page with a bunch of information, and the CDC forms are on there. So one of the big programs right now for tenants is the CHAP program for rental assistance. So Nevada is getting somewhere around $300 million to distribute to tenants for rental assistance. In Clark County, that money is going to be distributed through a program called CHAP, which is, I think it's the CARES Housing Assistance Program, which is being operated by Clark County Social Services. So CHAP is, that money can be used to pay your rent, to pay back utilities that you owe. It can even be used to pay security deposits and rent going forward if the tenant needs to relocate. It will cover up to 12 months for a tenant, and there's no cap on the amount. So we have seen some really big awards. The money is paid directly to the landlord or directly to the utility company. So the tenant applies for it through the CHAP program. The landlord will receive the money directly and will sign off for it. all of the application process is online. So the tenants can apply at www.chap.clarkcountynv.gov. They will be required to provide some documentation to verify their COVID related financial impact. There is also income limits on the CHAP program. So for the CHAP program, it's a percentage of the adjusted median income. And I believe that for one person, the tenant would need to make less than $60,000 a year to apply for the CHAP program. So unlike the CDC moratorium, which goes up to 99, the CHAP program is around 60 and below. But when the tenant applies through the CHAP program, it will walk them through all of those qualification procedures. So the other level of protection is AB 486. So AB 486 is a bill that just came out of the legislature. It has not yet been signed by the governor, but the governor has indicated that he supports it. And so we're anticipating that he will sign it. What AB 486 does, it creates two new defenses that a tenant can raise in an eviction case. It does a couple of other things, but these are the big, this is the thing I really want to focus on. So the first defense is that the tenant has applied for rental assistance and is waiting for an answer. So if the tenant asserts that defense, and they can assert it at any time during an eviction case, if the tenant asserts that defense, then the whole case is paused or stayed until there's a decision on that tenant's application. So if the application is approved and the landlord gets the money, then the eviction case is dismissed. If the application is denied, the tenant doesn't qualify for the CHAP rental assistance program, then the eviction will go forward. There's a provision in there that allows the landlord to dispute the defense, or if specifically if the landlord is facing imminent risk of foreclosure, that's likely when you would see an objection, or potentially the landlord could dispute it, the defense, saying that the tenant really hasn't applied or the tenant isn't really qualified. So we'll have to kind of see how that plays out. The second defense that is available under 486 is that the landlord either refused to accept the rental assistance once the tenant was approved for it, or refused to cooperate with the tenant in getting that rental assistance. So for the CHAP program, the tenant does the initial application, but the landlord has to verify the amount owed and has to give some tax information and has to accept the money. So if the landlord is refusing to do that, then the case will, and the tenant raises that as a defense, then the case will be stayed and potentially dismissed. The other good thing about AB 486 is it really is sending most cases to mediation. So now all those defenses, importantly, are available in most types of eviction. So there has to be rent owed, but let's say rent is owed, but I'm being evicted for a lease violation. Okay, that's covered by 486. Let's say rent is owed, but I'm being evicted for a nuisance. That is covered by 486. So the point was to get around tenants or landlords avoiding the non-payment evictions by saying, look, if any time there's rent owed and the tenant is applying to get rental assistance, then 486 is going to apply and those defenses are available with the tenant. Okay, so these are the things that we've really been encouraging tenants to remember. One, apply for rental assistance. Absolutely apply for rental assistance. And we're still hearing tenants, we're talking to tenants every day. We're saying, well, wait a minute, I didn't even know there was a rental assistance program. So whatever you can do to get the word out there and encourage tenants to apply, absolutely, absolutely they should apply. If they have already applied, They should go into their account and update their application, make sure all of their information is current, make sure all the documentation that the chap needs has been provided. 2, tenants should sign a CDC declaration. Now, I kind of bashed the CDC declaration a little bit because it really doesn't provide the protection we were hoping. And it, in large part, with AB 486 now in the works, assuming it's signed by the governor, that will provide a level of protection beyond the CDC. But there's no downside to a tenant, if they are qualified, signing that declaration and giving it to their landlord to try to get that protection. 3, and this is where you all come in. If a tenant receives an eviction notice, they always need to file an answer. There is really no reason that a tenant wouldn't file an answer. Even if the tenant intends to leave the property. Let's say I'm a tenant and I receive a 7-day non-payment of rent notice. I could leave during that 7 days, but what's going to prevent the landlord from filing a complaint with the court and getting an eviction? I don't want an eviction on my record. So the way I protect myself is by filing an answer and telling the judge, I left, I'm gone. So there are so few instances where a tenant should not file an answer. It's always a good idea. It's easy to do, and it's the way the tenants can protect themselves. If the tenant files an answer and they have applied for rental assistance and they are eligible to assert those AB 486 defenses, they should absolutely indicate that in their answer. The answer form is being revised so that the tenant can check some boxes and assert those defenses. If a mediation is available to the tenant should absolutely elect to go to mediation. There is no downside to mediation. It is simply a process where a mediator sits down with the landlord, with the tenant, and tries to help them work something out. The last thing we're saying to everybody is, if you have any questions, if the tenant has any questions during this process, because there's a lot of information, they should call legal aid. We have an eviction prevention hotline. If the tenant calls our main number, it's one of the options. They can always call. Somebody will answer the phone and give them correct information. All right, so the next thing that we're going to cover is the Guide and File program. And that's the online program where tenants can prepare and file their answers. I did want to touch on one thing. There is a new Guide and File program that is called Summary Eviction, Delay or Set Aside an Eviction. And this program would be used after the eviction has already been issued. So if the court has already issued an eviction order, this is what the tenant would file. So just as a reminder, that's the very last step that we're talking about. So it could be that the tenant didn't file an answer, so the eviction was granted by default, or it could be that the tenant did file an answer, but the eviction was granted anyway. So regardless, if the eviction order is issued, the tenant does have a couple of options, and that's what this interview is for. So I did want to clarify the difference between a motion to stay and a motion to set aside. A motion to stay, tenants oftentimes think, oh, that means I want to stay in the property. Kind of. What it really is asking the court to stay or pause the enforcement of that eviction order to allow the tenant some additional time on the property. It means, so the tenant is really saying, I intend to leave, I just need some additional time to leave. And the court has the power to give the tenant an additional 10 days to leave the property, but that's it, 10 days. You can usually only file one motion to stay per case, and oftentimes you can't file if you've already had a hearing. The assumption being that if you were standing in front of the judge, you should have asked for it then. But it is potentially a short pause to the eviction process. Now, a motion to set aside is the tenant saying, I don't think that eviction should have been granted in the first place for some legal reason. So a legal reason is not, I don't have any money or I can't pay my rent. That's not a legal reason. A legal reason would be, for example, the landlord never served me with an eviction notice, or the landlord misled me and said and told me that I didn't have to file an answer with the court. It's some legal reason why the eviction was improper. So those would only be filed after the eviction order is issued, obviously, because that's the thing you're trying to set aside. But it doesn't necessarily pause the eviction process. It could if the judge wants to set a hearing, but it may not. All right, so now we really, after all of that, we're really coming to the meat of the presentation, which is the guide and file video, the guide and file training. So it's a super cool program. As I said, there's a pre-recorded video that I'm going to show that where two of our staff attorneys are role-playing and kind of walking through the guide and file program, showing how it operates. There is a fee waiver available. So as part of this program, it will ask the tenant a number of questions to see whether they qualify for a fee waiver. To qualify for a fee waiver, there was a new law that just came out of the legislature. What the standard is 150% of federal poverty level. So it's pretty low, but right now, a lot of tenants are going to qualify for it. So you'll see that in the video.
So I'm going to be presenting the portion with Ryan about how to use the Tyler Guide and File program that Jim was mentioning. So what is the Tyler Guide and File program? You see the next slide?
Yep.
Okay. So like Jim mentioned, it's a program like TurboTax for legal documents. So it lets the users from home, from the comfort of their own computer, even phones, answer a bunch of questions. And at the end, the forms populate and they can actually be filed with the court. So the beauty of this, especially in this pandemic, is that people don't have to leave their home in order to file a response with the court. So the two interviews that are completely integrated with Las Vegas Justice Court, and when I use the word integrated, I mean these are the two interviews that can actually be start to finish done from home, are the tenant's answer interview and the proof of service of a CDC declaration. And we're going to talk about both those interviews today. This is the website that you will hopefully be using a lot with people to help them get through the process and file from home. So a couple of important things that I just want to highlight before beginning, and a lot of this will make more sense when we go through the actual exercise of going through the answer. The first thing is register, 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 and do that from the beginning. Register your user, the tenant, as soon as possible because it saves all the information entered into the interview. If the information doesn't get saved, you have to start all over again, and nobody wants to do that. The program works best on Google Chrome. So if you can do it from a PC, that's the best thing. Many people try to do it on Internet Explorer. It's possible. It's just not really great and compatible. So use Google Chrome. When we go back and make changes, you'll see, you'll just have to, in order to capture the changes, keep hitting next through all the pages so that every change is adapted. And I'll explain more about that as we go and show you how that works. So like I mentioned, these interviews are completely integrated with Las Vegas Justice Court. So if a tenant is renting in Las Vegas, this interview is going to take them from start to finish. However, if a tenant is renting in North Las Vegas or Henderson, there still is a lot of value to this interview. The only thing is at the very end, they'll have to save their PDFs and email those PDFs to these two addresses on the screen, North Las Vegas and Henderson. But still has a lot of value because it's the interview, as you'll see, is great at telling you what needs to be filled out and make sure that things are populated in the right portion. The other thing that I just want to reiterate that Jim mentioned several times, timing is everything. And the reason I say this is because I know that there might be a little bit of fear of like, oh, what are we putting in this answer? Is it the right defense? Are we choosing the right thing? If you get an answer lodged within the notice period, you're guaranteeing that tenant a hearing and you're guaranteeing that that tenant won't be evicted without the opportunity to talk to a judge. So sometimes a tenant might list things in the interview that you're kind of like, oh, I don't know that that's going to help them. An answer timely filed is 100 times and 100% better than no answer timely filed. So just get them in on time. And we have a script that Ryan and I are going to kind of go through that you can modify according to your own pace and style. But I think that it's going to be helpful in terms of speaking with the tenants who generally have a lot of information to share, and not all of it is going to be relevant to the interview. Okay. So now I'm going to share with you the interview. And here we go. So when I call scene, Ryan, who is a new attorney at Legal Aid, but in previous life was a thespian, going to be playing the role of our tenant today. And if you look closely, you'll notice that Ryan has been mistaken many times for Jason Bateman. Is that right, Ryan?
I mean, at least once. At least once. I'll take it, though.
I'm going to be, I asked Ryan what this was yesterday. Is it breaking the third wall or the fourth wall?
Fourth wall.
Fourth wall. So I'm going to be talking to you all as we go through this, but Ryan is going to stay in character as our tenant. So this is a list of all of our interviews that we have through the self-help centers, the Family Law Self-Help Center, the Civil Law Self-Help Center. You're going to be focusing on these two today. And that's what we're going to be going through. And a reminder, these are the ones that are integrated. So if you see one on here and you're like, oh, I want to help somebody file a small claims counterclaim, that's great, but it's not fully integrated for filing. So anyways, we're going to start here. This is the website, as you'll see up here, the address that we go to. I'm going to choose Summary Eviction Tenant Answer, and that's going to get me started. But remember, the first thing we're going to do is register. So here I go, and what I'm going to do is pretend that I'm calling Ryan as he set up an appointment with me, and we're going to go through the interview together. Okay, so Ryan, scene. Ring, ring.
Hello.
Hi, this is Lauren from Legal Aid Center of Southern Nevada, and I'm calling for Jason Bateman. Am I speaking with him?
Hi, Lauren. Yeah, this is Jason.
Hi, Jason. May I call you Jason?
Yep, that's my name. That'll work.
Jason, I see that you've signed up for an appointment with us, so I'm going to be asking you a series of questions, and based on your answers, I'm going to complete an online interview with you. At the end, we'll be able to file your answer with the court, and this will be in response to the eviction notices you received. Just as a reminder, I'm not your lawyer, so I can't and won't be giving you legal advice today. But because we only have a half-hour slot together, I just want to make sure that we get this filed on time. So I'm going to ask that you give me the briefest answers possible to your questions. Does that work for you?
Yeah, that'll work. I'll do my best to be brief, and I really thank you for your time.
Thank you, Jason. Okay, so I have your name as Jason, Jason. Is that correct?
That's correct.
And your last name, Bateman?
Yep.
And would you be able to tell me your email address, Jason?
My email is, well, it's pretty simple. It's Jason, my name, Jason, 1983 at AOL.com.
I love a classic AOL address.
Back when they had the discs.
And Jason, we're going to be making up a password for you today, just for this program. And to all of you watching out there, when you're doing these en masse, if you have several appointments, what I found to be useful is I just picked a theme that day that made things more fun for me personally, like what's your favorite fruit? Other days I chose colors, others I chose Halloween candy, whatever gives me joy that day. So today I'm going to say, and there are certain qualifications for creating the passwords, characters, numbers. So because I know that, it moves faster for me to just say, Jason, what's your favorite fruit?
Oh, my favorite fruit?
Yeah.
I guess I'll go with pineapple.
Pineapple, a goodie. And I'm creating a password for you, and at the end, I'm going to give you a couple of things that we'll need to write down. But for now, I'm just going to keep asking you questions.
Oh, okay.
And Jason, this number that I called you on, is this the best number for the court to reach you if they have any questions?
Yeah, this is my cell phone, the 580-4557 number.
Great. And will you tell me your address where you are renting and receive mail?
Yeah, my address is 1001 Ozark Lane.
And is there an apartment number or building number?
No, this is a house.
And it's in Las Vegas, correct?
Yeah, it's in Las Vegas, and it's 89167.
Thank you. Oops. Oh, sorry. In rehearsal, we created an email address for Jason Bateman. So guess what? I'm going to age you one more year.
Ah, devastating.
It's okay. Jason Bateman, like many people, get better with age. So
Really ageless.
He really is. And has more range as he gets older. And if you haven't watched Ozark, which is the inspiration behind this tutorial, you should. And you'll see that you've been registered because the email address pops up here. Something good to notice, if you don't see an email address up there, stop right there and register. And you can register at any time during the interview. Okay, so a lot of these initial screens are informational. I suggest that when you play around with it before you take on actual tenants, read through them. And tenants who are doing it themselves should absolutely read through these start pages. But for the sake of this exercise and to move quickly, I'm going to kind of fast forward these. This is actually a very helpful informational video that will guide you through how to actually work this. It's probably as fun as watching me and Ryan play this part, but it is also very helpful. Understanding self-representation, of course, because we're not their lawyers, as they fill this out themselves. It's going to tell you what forms will populate and what information they'll need. And then, so we already know, he said that the city is Las Vegas, where the rental property is. And Jason, you said you're living at Ozark Lane and you received a notice in regards to Ozark Lane, right? You're being evicted from your home?
Yeah, I got 2 notices actually.
Okay, so I know he lives there. I'm going to choose residential tenant. Now I'm going to stop here and show you what a tenant would be looking at. Ryan, do you see that notice? Jason, do you see that notice? I'm sharing my screen. Can you see lease file?
No, it's still on the guidance file.
Okay, excuse me while I switch screens here. So what Jason Bateman is looking at is how about now?
There it is.
So Jason was served with a 5-day notice to perform lease condition or quit, which he's going to be looking at. For the sake of this exercise, I'm going to pretend like I can't see this. I would really suggest that if you have tenants who are able, ask them to screenshot pictures of the notice to you. It will move a lot faster because you can see exactly what they're looking at, and it's very helpful. So for Jason, he received this first 5-day notice to perform lease condition or quit. And as Jim noted, you'll see the reason why they're being evicted here. So this reads that this section of the lease agreement prohibits pets, and tenants are housing 2 birds and 3 hamsters. And a section of lease also prohibits unauthorized tenants beyond those listed in the agreement. And the landlord believes that there are additional people living there. You're going to get a lot of questions about, this is blank. Is this a real notice? The answer is, that's not for you to decide. That's for a judge to decide. Many times this declaration of service is blank, but the landlord has their version, which is actually all filled out, and you don't take chances on this file within the time period, right? So this notice, as we talked about, as Jim talked about, all the notices that are really not non-payment are 2 parts. So this one says, hey, you've got 5 days to fix these issues or else I'm moving forward with an eviction. So 5 days after, the landlord wasn't satisfied, still thought that Jason was housing hamsters. So what do? They serve Jason with the 5-day notice of unlawful detainer, which is part 2 of the eviction process. And you'll see that this is what he'll be looking at. There's the date of service. That means that the clock starts ticking the day after December 14th is when you start counting the 5 days like Jim went over. So again, this notice says, hey, file an answer otherwise, and here's a link to what you're going to be helping people with. And if you don't, you might get evicted. So let's go back to our interview that Jason's going to be playing the part of. Okay. Are we back on the interview, Jason? Can you see?
Yep.
Okay, super. Okay, so this question, if he received 2 notices like that, or if he received the 7-day non-payment of rent notice, the answer to this is no. A summons and complaint is a formal eviction, which this interview isn't for. A summons and complaint will say summons and complaint. So if you don't see those words, the answer is no. And this question says, which of these notices were you given? Well, I already know from Jason, he got the 5-day lease violation notice, but you'll see that all the choices are here for the summary eviction. So just to clarify, Jason, you said that you received a 5-day notice to perform lease condition and an unlawful detainer. You got 2 notices, right?
Yeah, those are what they say.
Now, can you look at the 5-day notice to quit for unlawful detainer? And can you tell me if there's a date of service stamped on there?
Yeah, I think it's in red here. It's December 14th.
December 14th. So I know when I look at my trusty calculator, like Jim showed us, or not calculator, calendar, the 14th was a Monday, Tuesday, Wednesday, Thursday, the 17th. Today is not a court day in Las Vegas Justice Court, so 21st, 22nd. I know by the end of the day on the 22nd, Jason needs to have his answer filed. So have more than 5 business days passed since that date? No. Jason, have you heard about the CDC halt or stop or pause on evictions?
Yeah. I gave my landlord Donna that a while ago.
You did.
I gave that to her. Yeah.
Great. Now, for this interview, if your tenant had not done it, you would choose no, and it would run you through additional pages to see if they qualify. For the sake of this exercise and moving it along, we're going to say that he's already given the declaration. But the interview will work both ways. Okay. Oops. And as we've all learned to become during COVID, just be comfortable with the silence. And yes, it is a bit repetitive. You have to type things in a couple of times just from difference between registration and the actual interview, the actual stuff that's going in the form. And Jason, is your rent subsidized by Public Housing Authority or any kind of governmental agency?
No, we pay it ourselves.
Okay. Now, when you look at your eviction notices, Jason, do you see another name on there? It's addressed to you, but is there someone else?
Yeah, it's addressed to me and my roommate, Laura Linney.
Okay. And Laura's a person, I'm assuming, right?
Laura is a person.
She is an individual. And is her name Laura and then Linnui?
Yep, that's correct.
Thank you.
Good guess on the last name. A lot of people spell it IE at the end.
Oh, well, they're not as cultured as I. And when you look at those notices, Jason, do you see the landlord's name?
Well, it says from the Ozark group. I always deal with Donna. Donna's the lady I always talk with, and she's just a real jerk. But this says the Ozark group. I don't know who they are.
Okay. But Donna's the property manager that you always deal with, but she's not on the notice, correct?
No, she's not on there.
Okay. So an important thing about filling this out is, as much as possible, we want to match the information as it is in the notice. And that's because the clerks are going to link what the landlord files with what Jason files. So if he didn't have the notice, or he lost it and he's like, I don't know what was on it, but I deal with Donna, sure, he could put Donna, but what's going to end up happening is the courts are going to shuffle around a little bit and have to match it by address, which can cause some complications. So let's avoid complications and stick with what is on the notice so that it's consistent throughout, because we know the landlord's going to put that on their complaint too. Now, can you tell me what the address for the Ozark group is, Jason?
Yeah, they have a PO box 14365.
And is it in Las Vegas?
Yeah, it's Las Vegas, Nevada, 89110.
And is there a phone number for the Ozark group on there?
It's 702-580-5555.
Thank you. Now, this is the first defenses page. These are all the common defenses to a lease violation notice. Because I'm familiar with these, what I do is I hit none of the above, and I'll tell you why. I go to the next screen. What you can do is you can read through the laws and all the defenses and read them each individually to the tenant and say, which ones of these do you check? But I'll tell you what I do. I skip to the next page where this is the tenant's opportunity to tell me what their defenses are, and then it helps me go back and check the ones that I think will work. So what I'll do is this. So Jason, I'm going to ask you for about 3 sentences. And in those 3 sentences, if you could just explain to me briefly what your defenses are, why you don't think you should be evicted, and why you think these notices are wrong, and what you want the judge to know. And I can only type exactly what you say to me.
Oh, okay. Well, so the notice says I had 2 birds and 3 hamsters and someone else living with me, but I don't. My sister was visiting, and she brought her birds and hamsters with her, but only for one night, and then she left, so she's not here anymore.
With her,
So,
and only for one night.
So I think I don't think it's really about that. I think I've been having trouble paying my rent the last couple months, so I think that's what this is really about.
Thank you, Jason. Okay, so this pretty much fits in there, but if we had gone on for a little bit longer and you needed more room, what you can do is just cut this, say, yes, I need additional space, and then continue with your information down there. And all it will do is populate the form so that there's no overlap on text. So I'm going to hit next, but like I said, I now know what Jason's defenses are, or what he's trying to articulate as his defenses. So I'm going to go back to that one page where I chose none of the above. And instead of choosing none of the above, I think a good defense is the conduct of the landlord describes is not a lease violation because he was just having a visitor. Not a lace violation, a lease violation. I fixed the violation within 5 days. Well, if it was a violation, maybe you fixed it. So those are a couple of things that you can include. Again, what's most important is that you get this in timely. So I'm going to hit next. And then remember, like I told you, in order to capture that change, you just have to keep going through the interview and hitting next again. And what I mean by that is don't just go here and then skip this page and skip to general defenses. Just keep going through the pages and hit next. Now, another helpful thing that I want to note is this blue line right here. Look, we're almost done. You can see how far we've made it. So I know that, I've got 10 more minutes with Jason. I'm coming up on that. That's okay. We've probably only got a few more minutes left. Okay. Now, Jason, if the unfortunate situation did happen where you went to court and the judge still ordered an eviction, would you need more time to move out?
Well, how much time do they give me?
That's a great question. After the court hearing, the judge sends the order to the constable, who then posts the order on your door in about 24 hours. After they post that notice on your door, then they lock out within 24 to 36 hours.
Oh, so I basically have 2 days.
Could be.
So yeah, no, I've been in this house for 10 years. I've been hoarding all this stuff. I have all kinds of stuff in my basement. I have fancy equipment down there. I need time to get all of that out of there.
We can only ask for a maximum of 10 days. How many of those days would you want to ask for?
All of them, as many days as I can get.
Oops. And these are also defenses, I'm sorry, I skipped through that you can go through with the tenants and read them and see if they qualify. Based on, again, my familiarity with the interview, I knew that these probably weren't going to apply to Jason. So skip into the next page. And Jason, can you explain to me again in a couple of sentences why you would need more time to move out? You said you've been there for 10 years.
Yeah, I have 10 years worth of things in there, and I have most specifically, I have a bunch of fancy audio equipment in my basement that I just need time to. You can't just throw that stuff out the window, and it's a basement window too, so that'd make it even harder. So I need all this time.
I need time to move out.
Yeah.
Okay. And how lovely it is that you have a basement in Las Vegas.
Well, it stays cool during the summer.
Oh, that's great. Okay, so no additional space needed. So Jason, you told me that you gave Donna a copy of the CDC declaration. How did you give it to her?
I sent it to her email.
Okay. And when did you send that to her?
I sent it to her on December 1st.
Ah, okay.
I think, yeah, December 1st.
And so this question automatically populates to, did they give it to the landlord who's on the notice? He's saying he didn't. He gave it to Donna, the property manager. Do you know Donna's last name?
No, she's just Donna.
Okay. Kind of like Cher.
Kind of like Cher. Yeah, she's much meaner than Cher, though.
Oh, I'm going to put Donna, property manager, here. If all you know is that her name is Donna, then you just put Donna. But what email address did you send it to?
Just donna@gmail.com. She must have joined Gmail early. I can't believe she got that one.
Well, she's not a classic like you, Jason. All right, so you'll see that the answer portion is completed. Now we have to start the filing fees portion. Jason, in order to file this answer with a court, it costs $71. Will you be willing to pay the $71 today, or would you rather ask the court to waive those fees?
Oh, no, can we ask them to waive it? We don't make much here.
We sure can. I'm going to ask you a couple of questions about your household income. Now, how many adults live in your home? Is it just you and Laura?
Yeah, just the two of us.
Okay, no children?
Nope.
And Laura is an adult, correct?
She is.
Okay. Do you get any public assistance or Medicaid?
Our income's from Social Security.
Ah, okay.
But no Medicaid.
So, and how much do you get from Social Security, the two of you?
Combined, we get about $1,400 a month.
Any other sources of income?
No, that's it.
Oops. All of these have to be populated with zeros. Okay, so we're gonna hit next. And Jason, you declare under penalty of perjury that everything you told me is true and correct, and you're unable to pay the filing fees today?
Yeah, that's correct.
Now, this page is a survey page, which is extremely helpful to us in terms of coming up with better ways to express ourselves and ask the questions. So if you have time, please encourage your tenants to fill out the survey or help them fill it out, because sometimes they're just very helpful in helping us share with courts how many people are actually using this and how much time it takes them and how useful and helpful it is, especially in times like this. But for the sake of today, I'm going to skip through the survey. Okay, Jason, it looks like we're all done. I'm going to start reviewing your documents, and then we'll be moving on to filing.
Okay.
And so these are all the forms that have been populated. You have to review every form before you file it, and you choose view, like I just did. I'll show you on the next one a little slower. But you'll see that everything's populated in here. It's been served with a performed lease condition. Here's his address. And just to triple check, Jason, your address is 1001 Ozark Lane. Your phone number is 580-4557, and email jason1982@aol.com.
Yep, that's right.
And you'll see that the appropriate portions of the form are filled out. Here are his offenses, and here's the statement that he wrote. The continuation is on the addendum, which is right here. And you'll see that it populates today's date that he's going to file, as well as his signature line. Now we have to, go back to the summary. We have to review the next document, which you'll see right here. This is his proof of service that he gave the declaration to Donna. And the right box is checked by email to Donna, the property manager, at the following address on such and such date. And you said you emailed it to Donna on December 1st, right?
Well, let me check. Oh no, you know what? I apologize. I emailed it to her on November 1st. It was a while ago.
Okay, no problem. So what we're going to do is go back to the summary. We're going to hit return to interview. And I'm going to hit this blue button that says completed, because I remember that it was in that interview where it asked me when we gave Donna the declaration. So what you just have to do is find the page where you entered that information. And I know it's on this page, proof of service page. So I pull that back up again, and Jason says he needs to change this to November 1st, 2020. And then remember, we have to hit next and keep going through the interview until it's completed, so that it captures all those changes. And we have to go through this one again, but the information is not lost. All you have to do is click through. Next. Next. Oh, one other thing that I wanted to share with you. When going through that fee waiver, you may have noticed that Jason had told me how much money he had made. And one good thing to note is it's always up to the judge. There it is.
There we go.
So that's the Las Vegas Justice Court fee waiver guide. They go off 132% federal poverty level. So if Jason had told me, hey, together we make Social Security and we make $1985 together, I would say, I don't know if you're going to get approved for a fee waiver. So just be on the lookout that if you are denied, the court will be calling you and asking you to pay the $71, either by coming to court and paying in cash or by paying over credit card over the phone. There is an opportunity, if it's very close, for the tenant to plea with the court, make their statement as to why they aren't able to afford the 71. But generally, I knew that he and Laura made $1,400, which is $500 less than that standard. So I'm fairly certain, even though I can never really say because I'm not the judge, but I'm fairly certain he'll get approved. Okay, so back to the interview. Here we are, goes back through the survey, and We have made all those changes, so I'm just going to have to review them and double check that those changes were captured. Here we go again. So you select, you view. You can also download. If you are doing a North Las Vegas or Henderson complaint, download them, save them to PDF, and then that's what you're going to email. But for today, we're going to view this, and you'll see that all the information is still there. The answer wasn't really changed, so that looks good. I'm going to go back and review to make sure the proof of service was changed to, and sure enough, there it is, November 1st to Donna@gmail. And then here is the fee waiver that gets populated based on Jason's income. 2 adults, $1,400, signature, populated. Now, we reviewed it, so all these check boxes appear. The next thing we're going to do, hit next. All right, Jason, we're getting ready to file.
Oh, all right.
Now, you'll see here on this screen, it's telling what exactly the filings are going to be. These are just codes. The filing fees are waived. If you are paying, if a tenant is paying, it follows basically a regular credit card page. And we submit now. And then we just cross our fingers and hope that this interview works. All right. So this is an envelope number, which is very important. This is the one that you want to write down for your tenants. So what I'll say is, Jason, I'm going to give you 2 very important things to write down today, okay?
Okay.
The first is for your password. Your password is pineapple with a capital P.
Pineapple. I'm sorry, go ahead.
Pineapple with a capital P, 4567 #, or hashtag, as the kids say.
Okay, so capital P, pineapple, 4567 hashtag.
Yes, sir. And your envelope number is 711-3984.
711-3984.
Yes.
Okay.
In just a couple of minutes, you're going to get an email from the court at jason1982@aol.com. And Odyssey Guide and File is going to tell you that they've received your filing for processing. But in about 24 to 48 hours, you're going to get an email again that has your documents file stamped, and that means that everything's gone through. If you get any kind of email that says it's been rejected, well, then you'll have to call us back.
Okay. Okay, so right now we're done?
Right now we're done. The important thing you have to remember is just to look out for your email and look out for your mail. And you're going to get information from the court about your filings and when your court date may be.
Okay. Okay. Well, thank you very much, Lauren. This is much easier than going down to court.
You got it, Jason. Best wishes to you.
Thank you.
And see. Gosh, Ryan, you should not be a lawyer. You got to be you got to go back to acting. It's too good. Okay, so last things I'm going to share with you are just a couple more slides, and then we'll be finishing up. So I just wanted to give you a couple bits of information about legal aid. We assist victims of domestic violence, divorce, custody, TPOs, immigration cases, and we also have a consumer program, which Jim is in charge of, that helps with debt collection cases, payday loans, Social Security, bankruptcy, all that kind of stuff. On Legal Aid's website, at the very bottom, you'll see lacsn.org. On that website, there is a legal and financial toolkit, which is very helpful, constantly evolving with everything that changes every day with COVID. So we refer people to that all the time. Information about utilities, rent, anything that's going on that affects tenants right now, financially and legally, and eviction stuff. So keep checking on that toolkit, keep sending people those links. We do have free virtual community legal education classes. Anyone's interested in the small claims class, I'll be teaching that this afternoon. And we have telephonic Ask a Lawyer sessions. So every Wednesday, we have a volunteer lawyer who telephonically talks to tenants for 20 minutes each. And they can ask that lawyer for legal advice, how to proceed with their case, how to present their case in court, and all kinds of procedural questions as well. All of our services at Legal Aid are remote right now, so email, phone, all of it. And those are the numbers and emails you can use: 702-386-1070 or info@lacsn.org. And lastly, the Civil Law Self-Help Center, which is where I work. We provide self-help information to anybody who's unrepresented by an attorney in those civil cases. We call ourselves the Legal Emergency Room because we help with those kinds of emergency filings like these eviction filings, the guided online interviews, the ones that you saw. And in 2019, we helped more than 47,000 litigants. It's going to be higher this year, is what I can tell you. Our remote services are offered by phone and online chat. So we're open the same hours as Las Vegas Justice Court, 7:30 to 5:30, Monday through Thursday. So if you hop on our website, civillawselfhelpcenter.org, during those business days, you'll see one of our awesome agents on chat via the chat bubble. And you can always also call in during office hours at that number.
All right, so that's the video. And I think that's it for the presentation. I'm happy to take questions now. The guide and file is not complicated. Honestly, after you've done one or two, you can go through it in your sleep. So do not let it intimidate you at all. It's really, really self-explanatory. So if anybody has any questions, I'm happy to answer anything you have. So feel free to unmute yourself and ask.
Well, hey, Jim, it's Quentin. If you don't mind, I'll jump in first.
Go ahead.
Can you talk a little bit about what we can expect the mediation process to look like? I've heard a couple times throughout this training that the judge really doesn't have a great deal of leverage in making both parties come to an agreement. So what are we thinking the mediation step will even provide?
So the mediation really doesn't have anything to do with the judge, right? So before you get to the judge, the mediation takes place. So before you have a court hearing, you have the opportunity to mediate. And what mediation really is, the landlord and the tenant will sit down with a trained mediator, somebody who is trained in conflict resolution. And they will really try to figure out if they're to figure out whether there's any way for the parties to reach some resolution that they can both live with. That may be a repayment agreement. It may be rental assistance. Okay,
sounds good. Thanks, Keith. Bye-bye.
The mediator will have the ability to contact the CHAPS program. So if the tenant has an application for CHAPS or hasn't applied for CHAPS, they could potentially get linked into rental assistance through that mediation program. So bottom line, there's really no downside. It's an opportunity for the landlord, the tenant, to sit down face to face and see if they can reach some resolution of whatever dispute they're having. If it doesn't work, no skin off anybody's back, right? Like, the tenant doesn't have to agree to anything. The mediator is not going to make any decisions. The mediator is not going to force a solution on anybody. It's really up to the parties to see if they can reach an agreement. If they can, then the mediator will write that down. And if the parties reach an agreement, then the mediator will let the court know, and the case gets dismissed. The case goes away because there's no point in having an eviction hearing now because the parties have agreed to some resolution. So there is no downside to mediation. It will, if anything, at the very least, it will potentially extend the eviction process a little bit and give the tenant a little bit more time before that eviction hearing. So definitely, it's free. There's no cost to the tenant. So if you have a tenant who is questioning whether they should elect mediation, yes, they should absolutely go to mediation.
Thank you very much.
Sure. Any other questions? I did want to point out on that, the numbers on the fee waiver that Lauren was using in the video, again, as I pointed out earlier, the Nevada legislature just passed a bill to try to standardize those numbers between all the justice courts. So those numbers aren't quite right. It's now 150% of federal poverty. So actually the numbers that Lauren was using are actually a little bit higher now. Any other questions? All right then. So thank you, everybody. If you
Oh, well, I didn't want to take up too much space, Jim, but if nobody else has questions.
lay it on me. Yeah.
Okay, so I wanted to clarify that the registrant on the Tyler site needs to be the community support, or is that intended to be, the registrant is intended to be the tenant?
The registrant is the tenant.
Okay.
So if you're assisting a tenant, you will be inputting all of the tenant's information, their address, their contact information, and importantly, their email address, because that registration is going to allow them to go back into their account and check on the status of things. So it is not the person who's actually, if the tenant's filling out their own forms, yes, it will be the tenant. The registrant and the tenant will be the same. If you are assisting a tenant with filling out that registration, it is not you, it's the tenant's info.
Okay. And then my understanding also from the training is that if you have if you are within the Las Vegas Justice Court jurisdiction, it automatically goes to the court. However, if you are in Henderson or if you're in North Las Vegas, you have to save that as a PDF and then you can email that to that court.
That's absolutely right. So the interview that Lauren did was assuming that it was Las Vegas Justice Court. So it's all integrated. You just, at the end of the interview, it just goes to the Las Vegas Justice Court. The other courts have a different filing system, so it's not integrated. But you can either do what Quentin said, and you can save the documents as a PDF and email them to those courts. And the courts are willing to accept those documents by email. If the tenant, for some reason, so what you would probably do, you would save them and then email them to the court and probably CC the tenant so the tenant has copies of them as well. The tenant can always go back into their account and get copies of their documents, but copy them on the email. Otherwise, the other option is for the tenant to actually print off the documents and physically take them down to the courthouse, which they can do if they want to do, but there's no need to do that.
When do they need to pay the fee?
So if they are applying with a fee waiver, it will all get integrated into the interview.
Okay.
Most tenants right now will probably be trying to utilize a fee waiver. So it will all be part of the interview process. One of the documents that will be created at the end of that will be an application to waive that filing fee. So that will get emailed to the court with all the other documents. And if it's approved, that will take care of the filing fee. Now, if they obviously will not qualify for the fee waiver and don't even want to try, they can input their credit card information into the Guidance file and pay for it right there. If they are filing in North Las Vegas or Henderson and are actually taking their documents in, they can take their documents in and give the credit card to the court clerk. If they apply with a fee waiver and the fee waiver is rejected by the court, it isn't approved, then the court will contact the tenant and either take a credit card number over the phone or tell them they need to come down to the court and pay the filing fee.
Okay, thank you, Jim.
Yeah, sure. Any other questions, anybody? I promise it's an easy process. If you have any questions as you're going through this, you can always call our landlord tenant, our eviction prevention hotline. The number is for legal aid is 702-386-1070. And I think that's the number. That will get you to the main line. Just press the option for the landlords for the eviction prevention line, and the advocate who answers the phone will be able to answer pretty much any question you might have. thank you, everyone, for any assistance that you can give tenants. We're anticipating a real crush of eviction notices. So the more avenues we can give tenant to protect themselves and to defend themselves in a court case and to actually avoid a default eviction, the better off. So thank you, everyone. And if you have any questions, please feel free to reach out to us. And everyone have a great.
I just wanted to say the Nevada Housing Justice Alliance is hosting a housing resource event this evening, 6100 West Cheyenne. So if you know community members that are looking to be connected to resources, that's one resource that'll be available tonight. I'll drop the address in the chat. We start at 5. And we start at 5, it'll end at 8.
Fantastic. Does anybody else have announcements like that? I will say that this weekend, we are holding pop-up events at the Clark County Library and the Whitney Library, I believe. Yes, Whitney Library, where from 10 in the morning till 6 o'clock at night, we will have people there who can assist tenants preparing their answers. So if a tenant has received an eviction notice, they can go to the library. We will have advocates there who will basically use the guide and file program to help the tenant prepare their answer. So if you talk to anybody and they are interested in the Saturday pop-up, that's available. We're also having pop-ups the Saturday on the 12th as well. Anyone else? Other announcements?
I just had a question. Can you please send some of this information via email after we close, like flyers or something, so we can share it with organizers and other people in the community?
Sure. And what I would really suggest, go to our website and go to our COVID page. On the home screen, there's a COVID page, linked to a COVID page. All of the information for legal aid, at least, all of the information is going to be on that COVID page. There's flyers for the pop-up events, where there's links to the guide and file program. Basically anything you need is on there. For the other information, I'm not really sure how to get that out to people. But yeah, I don't know. So any other questions, anybody? Quentin, did you want to give, do you have an email website that people can visit for?
Sure, you can go to makeyourworknevada.org, or you can visit our Facebook page, our Twitter page. The information for the event this evening is listed there. And I second what Jamila said. I was hoping that there was a flyer for the Saturday pop-up that we could get out to our network too.
Yeah, go to the COVID page. There is a flyer on there for it.
Thank you.
Thank you, everybody. Have a great day, and thank you so much for all your great work.